You said 11.5. Yeah. Um, Very good morning, everyone. This is Saraswati, Secretary General of the Madras Chamber of Commerce. And it gives us great pleasure to have this program, virtual program, jointly with StartupTN. I should thank the CEO of StartupTN, with whom I first had the dialogue, Mr. Shivaraja, and then thanks a lot to Mr. Maheshwar, who took this initiative within such a short time. Probably, if I'm right, Mr. Maheshwar, we discussed about it less than a week before. And I'm really happy that it is happening today. Maybe we can plan going forward well ahead and have a continuous series. Just to let me first congratulate all the entrepreneurs here. I think you are the nation builders. And it gives me great pleasure to meet you all on this day. It's a World International Property Day, IPR Day, if my Ms. Savithri can correct me. So that is the reason we chose this topic for this day. And just to give a very brief introduction about the Madras Chamber, this chamber is the oldest chamber in Tamil Nadu, South India, second oldest in the country. We are just 187 years old, started in 1836. And maybe many of the startup entrepreneurs of those days or decades before have become emperors here. And that is exactly the reason the chamber, with its long history, we have different initiatives. We have a startup ecosystem, what we try to do for the startup. We have a sustainable Chennai forum. We have a food for thought series where we take debatable subjects relevant to business and then take a very unbiased view. We have a lot of such activities. We have a very active women business council, things like that. In the interest of time, I'm not going to talk about those things. Maybe I'm sure we will continue to interact more and more. But இன்னைக்கு primarily, as I said, this IPR டேங்கிறதுனால, again, Ms. Savithri would confirm, today's theme, I believe, for the World IPR Day is Women and IP, Innovation and Creativity. So I'm really happy as a Women Secretary General, I am starting this program, and as a Women Senior Resource Person, Ms. Savithri is going to talk on the subject. And the idea again is we have different expert councils. So expert committees and many working groups and committees, women business, MSME, etc. So what we are planning to do, if Mr. Maheshwar, and we can discuss it further later, maybe we can just have this as a starting point and we can plan for a webinar every month. Even we can have a fixed day if you think, maybe third Friday, fourth Friday, or whatever it is, so that whatever the topics will be relevant to the small industries, since we have people like Ms. Savithri or different domain experts are here, we can decide going forward. Maybe after this meeting, you can also gather their opinion. கேட்கல அவங்கள்ட்ட வேற என்னென்ன டாபிக்ஸ் அவங்களுக்கு இன்ட்ரெஸ்ட் இருக்குன்னு சொன்னீங்கன்னா we can really cover taxation இருக்கலாம். ஏன்னா ஸ்டார்ட்அப் இந்த ஈவன் ஃபார் திஸ் டாபிக் we were debating ஐபிஆர்ங்கிறது ஸ்டார்ட்அப்க்கு எவ்வளவு தூரம் ரெலவென்ட்னு. then we realized lot of such issues. We can quote number of cases. I'm sure Savithri madam will also say about it. ஏன்னா இது ரொம்ப இம்பார்ட்டண்டா ஆயிட்டு இருக்கு இன்னைக்கு. It's even a sort of a legal, even financial, economic, all aspects covered in the IPR, not just ஏதோ high-ended பெரிய கம்பெனிஸ்க்கு தான் இது ரெலவென்ட்ங்கிற மாதிரி போய் இப்ப ஸ்டார்ட்அப்புக்கு இன்ஃபேக்ட் ஆல் த மோர் ரெலவென்ட். அண்ட் ஸ்டார்ட்அப் பண்றது கொஞ்சம் ஈஸி ஆல்சோ இன் த சென்ஸ் முதலேண்டே இதை பண்ண ஆரம்பிக்கலாம் ஸ்கிராச்லேண்டே. வேற எஸ்டாப்ளிஷ் ஆனப்பறம் இதெல்லாம் கொண்டு வரும்பொழுது லாட் ஆஃப் இஷ்யூஸ் கம். ஸோ அந்த ஐடியா, அந்த பேக்ரவுண்ட்ல தான் டுடே வி ஸ்டார்டட் திஸ் ப்ரோக்ராம். And I'm really happy to do it jointly with TN, StartupTN. இன்னொரு ஸ்பெஷல் பாயிண்ட் ஐ ஷுட் மென்ஷன், நிறைய சேம்பர்ஸ் காமர்ஸ் இருக்காங்க. மெட்ராஸ் சேம்பரோட யூஎஸ்பின்னு பாத்தீங்கன்னா we are exclusively Tamil Nadu focused. Though we call ourselves a Madras chamber, it is not just Madras. It is old Madras, which even had parts of Kerala, Karnataka, Andhra and all. இன்னைக்கு எங்களோட focus Tamil Nadu state. We are probably the only state which focuses more on the state and its development. அதனால it gives us double pleasure to do this jointly with the TN startup. Now, Sonamari, we could be a source of support, knowledge source, and sort of mentoring, hand-holding support to many of these startups in many areas. So that is exactly the idea to have this program to kickstart the discussion. So now, முதல்ல சொன்ன மாதிரி, maybe Mr. Maheshwar, we can take this discussion further. You can also get a feedback from your members. Maybe monthly at least to start with, ஒரு webinar பண்ணலாம் அவங்களுக்கு relevant. Then we can think of more serious long-term activities together. So we are very open and we will be extremely glad to support and any sort of help the entrepreneurs, members require. please, you can pass on our contacts and we would try to do our best. Thank you so much. So before I ask request Ms. Savithri Suresh Babu to take over the screen, let me just briefly introduce her. Ms. Savithri Suresh Babu is a senior associate of A.K.Mylsamy and Associates LLP, a very old legal established firm and a member of the Madras Chamber. And she has a master's in law from Dr. Ambedkar Government Law College, Pondicherry, now Puducherry, with specialization in administrative and labor laws, added with a master's in insurance management, a university topper and gold medalist in undergraduation and post-graduation, holding 25 plus years of experience both in corporate and litigation domain, and has brought tremendous learning working exposure both nationally and internationally. She has developed a very keen passion on this IPR, and that is the reason right from day one we had been discussing with her on this session. And she's being practitioner in IP with special mention in geographical indication. As you all know, அது இப்ப நிறைய importance gain ஆயிட்டு இருக்கு. You would have been reading news articles in the recent thing of very, very traditional items getting that authentication. So you can talk to her on the trademark, copyright, industrial designs. She acts as a facilitator for NIPAM and she has spearheaded many awareness programs in AP. So, request enna, please put your mobile audio video in silent mode when she presents. And maybe after that, she will, I think she would present for half an hour, madam. And then it will be open for questions. So, you can feel free to ask her bilingual, English, Tamil, wherever, whichever you are comfortable with. And she would be very, very glad to answer. So I would stop here, leave the floor to the expert and to Mr. Maheshwar. Thank you so very much. Once again, I wish you all great success. You all should reach greater heights, and we are there to do whatever possible as a chamber. Thank you so very much.
Thank you. Thank you.
Thank you, ma'am, so much for this introduction, actually. As ma'am was rightly said that our firm A.K.Mylsamy has been here for almost 58 years and we are leaping strong. We also take our gratitude, try to express our gratitude for MCCI as well as the startup mission of Tamil Nadu for giving us this opportunity as a resource person and to create an awareness among the young startup entrepreneurs in Tamil Nadu. Let me take in the session. I would like to share the screen for my presentation. Today, we are so glad to celebrate the World Intellectual Property Day, which falls on the 26th April every year. And it is so an important occasion that MCCI has crusaded in celebrating that along with the TN mission, which is serving for the startups and innovations. So though the theme this year is IP women and accelerating creativity and innovation, we are not confining only to the women entrepreneurs. This we try to create an awareness among the young entrepreneurs who are partaking and developing the economy. So when we take about WIPO, which is the World Intellectual Property Organization, it is a member country. It has about 193 member countries, and we work under the TRIPS agreement, which is an international agreement on trade-related activities. So this is also, WIPO is also a part of the UN. Though it is a self-financing body, it is a UN body. For every year, hundreds and hundreds of events have been organized to create this awareness on IP. Maybe it may be by law firms or offices or private companies or big organizations like MCCI and other bodies, which crusade to create this awareness on intellectual properties to the people, especially the young entrepreneurs as well as the startups. So we say that what is the need for this day? Because you may ask me, what is the significance of this 26th April? It is the day when this foundation has formed itself and come into existence. So in commemorating that, they celebrate it every year on 26th April, and it's commenced on 2000 with a theme every year. Fortunately, this year the theme is on women, though on women, we like to say that it can be also for the youth, because every year they choose up a topic. This is, what is the need? This need is to explore the different aspects of intellectual property system and how innovators, creators, or businesses can use it to add value to their ingenuity and creativity. The development of any society, we know that, should directly depend on the IPR, because now any startup commences a business on an technological innovation or an ideation. So to give shape to that ideation, what is required? Certain rights to be vested with them. They have to understand that that has to be protected. Because if it is a tangible asset, say for example, a land, a house, or a building, we can register, we can look physically, we can see how the existence is there any encumbrances, we see the clarity, we read the clarity and see if their title is proper. Then we acquire the rights and transfer the rights through a proper documentation. But if it's going to be an intellectual property, creation of a mind, an ideation, how do you bring this intangible form into a shape? How do you bring them into how do you vest the rights with the person who has created it? Because there is always a chance, always an opportunity for somebody to copy it, to use it, reuse it, or take it and replicate it. So what is the right vested with you? This is precisely what we're talking about, the intellectual property right. And awareness should also be there, because I would like to say that we have lost the giant marks or giant products in context with some member countries, especially with America. If you can all recollect the fiasco or the litigations that we had for a turmeric, a product of turmeric, which was tried to be patented by a company in US. We almost had to spend 8 crores from the government side to recover and say that that property is a geographical indication property of India, an Indian product. So this is because precisely we have not been proactive, we have not been vigilant, we have not disseminated IPR. So this information should be there, that awareness, because these days we see indigenous people, small scalers, small people from social economic backgrounds, even coming up with the thought of entrepreneurship. So we need that. So what is the basis for all of them is technological dependence. So technology again is nothing but you, based on the technology, you innovate, you bring in new products, new process, new methods, new inventions. So all this how to be protected. That is what we talk about, the right into intellectual property. And as I told you, we have this day commemorated though for women. Let's keep it for everybody. So next, as I told you, the startups and what is it about? We know that in 2016 the mission was started as by Arun Jaitley, the minister then of Industries and Commerce, who brought in this system of startups. And what is the Department of Industrial Trade and Industries and Investment Trade has recognized certain handholding method, fundraising methods, and incentives to be given, and also incubation. So how do they do the handholding? The legal support. First is, how do you do it? There is a web portal or there is an app which says that you have to comply with it. And when you comply with it or register yourself as maybe, you are with an ideation, the moment you have an ideation, you discuss, you want to create a company. So for the ease, because formation of a company is not that easy under the Companies Act. So ease of forming the company. So what are the types of company that can be formed? It's a limited company or a partnership firm or a self company, wherein have a self certification process, and you will be given an easy clearances for 9 of the compliances, including the environmental laws and the labor laws, when you get yourself registered under the mobile app or the web portal. Next, there is the support that is also being given in IPR. You can fast track your startup, your patent applications, because if you depend on a technology, you depend on an innovations, you depend on a new kind of a process. Say, for example, we have the EV vehicles coming up. We know certain products, certain brands that has come up. How did that all start? Where did the research happen? What was the protection? So, at the first instance, let's bring in that alertness or the awareness that this has to be protected. My innovation has to be protected. Least I don't lose it to somebody. So when I file a patent, earlier it used to take years to get a patent granted, but today what happens is you can speed up the procedure, the ease of procedure. We say Form 18A, wherein you can request for your examination the moment I file. Earlier, when it was taking 7 years, today we are able to get patents within a year. That too, the grant has been given. The fee structure in filing all these patents and other IPs have been reduced drastically. In case for patent, it has been reduced to 80%. Whereas if it's going to be a trademark, it's just 50%. So copyrights and designs also we are giving them the rebate. So everywhere the rebate has been given to boost, to encourage people to come forward to protect their IP. Likewise, when you are finding it that you are not viable to pursue, there is something hiccups in this. The wind up procedure is okay and very easy, because as per the insolvency and bankruptcy bill, if you can notice, the startups with simple debt structures may be owned up within a period of 90 days. That is the time limit given. So you just wind up and you exit. No more you have any janjats on holding that and go through the bankruptcy procedure, which is a lengthy one again. Next is about the funding and incentives. All of you should be knowing, because being a startup, how do you get it? So our TN mission, that is the TN startup mission, has come up with certain policies also. They give the fund of funds, they give the investments. This is from the DIIP I'm talking about, but also I would like to cross-refer with the policies of the TN, which has very categorically spoken about IPR also. When it comes to creating a conducive ecosystems for encouraging the entrepreneurships and innovations, Tamil Nadu is well endowed with the science and technology engineering tool, which we know all of us have. We have a large pool of that. This indigenous individual capital would be the strengthened and leveraged to create entrepreneurial ventures through the following plan of action. This is available in the Tamil Nadu state startup policies, where they say that a central registry come repository on venture firms, incubators, intellectual property support centers, mentors, database of different talents for startups to hire, share stakeholders and other activities will be supported by the government of Tamil Nadu and as well as the government of India, and which can be leveraged for the startups as well as their establishments. And we know that Tanzan also is also trying to identify and empanel private IPR centers to partner on engage with startups, networks, associations, co-working spaces, etc., to provide IPR guidance to the startup. Now, existing IPR supports also will be strengthened to serve the Patent Information Center, which is a very crucial portfolio among the IPRs that is available, as well as you have the Intellectual Property Facilitation Centers. So this is the policy makeup of TN with regard to IPR. Now, when we come to incubation centers, which we know about that, there are so many incubation centers sponsored or private also. Sponsored by the governments, we got the Atal, which is also functioning very well in some of the districts, as well as the private partnerships with the missions. They, in a partnership, can create an incubation center for incubating the startups. And likewise, we have for different segments, like in Taramani, we have it for biotechnology. So it is a separate incubator which looks into biotechnology also. So all these centers, that's what I was trying to say. There are about 31 innovation centers, 13 startup centers. This is the old statistics, but we are yet to wait for 22-23, and about the grants that is also being given. Let's take about all the grants that has been given for student innovations from also entrepreneurships. Then we have the Uchar Avishkar yojanas. Then we have the annual incubated grants challenges also. Then under incubations, we also have organizing Startup Fest, which we normally do. We have this Chennai Tiruvira, which is coming up, I think. So TN Tiruvira, all this kind of initiatives and plans to create and promulgate that, thereby creating an awareness not only on IPR, but the other aspects also. Now, let's move into how the startup and intellectual property is created. So, as I told you, it facilitates a protection for patents, trademarks, designs of innovative and interesting startups. So, the governmental schemes, various governmental schemes are available, which will handhold anybody, any entrepreneur who is trying to find out how to protect his intellectual property. Then they also help to protect and promote intellectual rights for the startups, as I told you, by all these various schemes that is available under the Government of India, or it can be even under a TN Startup Mission. These primary objective is to create and encourage innovation and creativity among the startups, and awareness, adoption of the intellectual property rights. As I told you, the first thing that anybody who is dependent on a technology or an innovation, the moment it gets moved from the stage of ideation to that of innovation, you have to protect, because it is your brainchild. The moment you protect it, only then you can exercise the right. Because even I can give you an example. There are a humpty number of applications being filed. Though we call this IP as a territorial right, that means it is confined within the country, and there is always a scope that somebody else is also thinking. I happened to see a read wherein Einstein was asked, it was so nice that you brought, sorry, Graham Bell was asked, it's so nice that you brought up this phone for us. You have introduced this. So the technology has risen up. He said that, not me. There are so many. Had I not filed it in time, there would have been others who have been, because there are also a number of people working on the same. So every time people are working on these innovations, people are trying to improvise these innovations. That is why when we see a patent, it doesn't give patent protection per se for the product. It gives even for the process. So no more gone are the days when somebody comes out from the bathtub, says, Eureka, I found it. It is like everybody is working on the technological advancement. People want to take it further. And so the initial protection, as ma'am said, the initial awareness and thereby the protection is very, very essential. And the scheme is inclined to nature and mentor innovative and emerging technologies among the startups. We also assist and protect and commercializing it by providing, because gone are those days just for compliances. People file a trademark because they say that, ma'am, as per the thing, say, for example, you're going into an e-service portal. When as per compliances, they will ask you, you get a trademark registered and come, only then we can get you your products up on the e-commerce site. There what happens is, for mere compliances they'll file. No, that should not be the case. IP is a portfolio by itself. It has to be having an asset value, because the moment you start branding, your brand has a value. So it is like anywhere, any company that you're going to invest, you go for a physical structure. You go for articles of association. That means you form the members of the company. You have an investment. Likewise, a similar investment is essential for your IP. So when I'm talking about IP, so what is actually IP? What are intellectual property rights? It's a right over the creation of your mind, or a product of human intellect. So we see that electric vehicles, two-wheelers come up with electric vehicles. Where did it all happen? So somebody was researching, somebody was working on it. Before somebody can introduce it, somebody else also is working on it. So if they become competitors, so how do you protect it? If the date of filing, the date of invention, if you are able to establish, you are able to show that you are the person first in the list, then it gives you the absolute right. It gives you the monopoly. So you can stop, or you can say that, see, this is my invention. This is my invention. How can you take it? So how do you protect it? That also we'll talk. That's why we are talking about exclusivity. It gives you a monopoly, means the absolute right. Even when you're talking about any land, I'm talking in comparison of an intangible right with that of an intangible property. Just equate and see. A tangible property is a physical property visible to your eyes. You can see that, you can understand that the physical existence is there. So you take all pains to see their existence, whether they have absolutely what is your requirements, and then you say, yes, my title is intact. But what about this intellectual property? You don't know who else in which corner sits to work on the same. So you want yours to be protected, and you want the absolute right on that. So that has been granted by this. So what you ask me, ma'am, just by registering, will I get an absolute right? No, you have to also be equally vigilant to protect your rights. Because say, for example, you have a property, you're leasing it to a tenant. What happens to him? You go occasionally and visit your property. You tell them these are only limited rights that I give you. You cannot exercise and take more than what I give you. So that we reduce it in the form of a lease agreement or a rent agreement, or if you're transferring it, a sale, you give them as a absolute transfer. Then you see that whoever is buying does a due diligence on your title, on your absolute title. He sees there is no encumbrances. How did you get the title? So same way here also, once you get the right, you are also vested with the right to divulge or sell or franchisee or assign that particular right. So we are bringing an intangible right into a tangible one. So we are creating, we are giving you that exclusivity or monopoly over your creations or your inventions. And also that recognition is there, because otherwise how will you have a holder title? And as I told you, every brand, every product, when it comes to commercialization, it has a value. It has to set a value. Say, for example, we always see that say if it's going to be a textile brand, let me say Allen's Only or Peter England or something of that product. When you bring that brand, you have an annual sales. So that particular brand will fetch you the right for that particular brand. So how much is the value for also turnover for that particular brand? So that is the value, brand value for that particular intellectual right. So when you have this Allen's Only, you always get to remember a DMark with an stag. So how does that get imbibed? That is again a look. That is also human creation, right? You created, you coined, you gave a shape to that form and created a brand. And that is your valuation. That is your exclusivity for your creation. But why should it be protected? That's what I said. It is a growth. It is for the growth of economy. It is the social need. Now everybody, a startup comes up, he develops an app. He gave in that app, maybe there is some aggregations done per se, that will not, the app may not be developed just only with the process. Some add-ons may be there. I can give you a classic example. The reason battle that is going around between Apple and Alive Corp, wherein it is the cardiac cart. That is an app which was developed by this Alive Corp, wherein they have used it in the Apple Watch to check the ECG, measure the ECG. But what happens is Apple per se was using it as an add-on app in their watch. But now they understand that that is not their invention. That is, they have not patented it. So somebody else has already patented it, and they have been put in use. Now that war is going on. So the future of Apple Watch is at stake because of this particular litigation. So how do you see this? How do you take it? So we are saying be vigilant, in the sense this is what we are talking about. Somebody else in the market has produced it, yes, but he has come as a prior person who has registered. So that person can also protect. So Alive Corp will protect its rights because it is its invention. They have brought up that app for measuring the ECG, that is through the cardiac cart. Next is, that's what I said. This will give you prima facie a proof of your ownership. I own it. So what is the legitimate paper that you have with you to say your invention or your ideation has taken shape? Is the registration process that happens through our IP registry. What happens when intellectual property is not protected? As I told you, this violation of your exclusive right. So somebody fails it, but somebody else has it. How do you protect it? We see there's a lot of counterfeited products in the market. When these products are in circulation, it will affect my sale, it will affect my brand, it will devalue my quality, because I come up with a particular quality, I come up with a particular methods, I invest. So if there is somebody counterfeiting my product, they are misusing my product, they are putting it in the for sale in the market, I have every right, be it under trademarks or be it under copyrights or anything, to take proper action of infringement. Or if they are passing off the goods, say for instance, they will be using the same kind of a label. Because if you talk about a trademark, maybe once I come on to topic, I'll just let you know. Trademark is not just a logo or a bird brand. It also includes the color. It also includes a sound. These are all unconventional marks, but still, even to that extent, an individual also can protect his right under a trademark. So once I am taking up on the topic of trademarks, I will let you know on that also. So so protection of intellectual property right, as I told you, what is the means? Since I said what is the need for protection, let me also tell you why you should protect your intellectual property right and how. So how do you protect it? By registration. The process may be by filing an application under the Trademarks Act, or it may be under the patent or under industrial. So we have different jurisdictions handling this, those centralized in Delhi. It is called the Controller General of Intellectual Property Office, and we have offices in Delhi, Calcutta, Ahmedabad, Bombay, and in South it is Chennai. And these offices look into the registration process. So there is a means of e-filing it. And here is what we say about the grant that has been given under the SIP program, which is nothing but the Startup Scheme for Intellectual Property program, wherein there is not only awareness, they also provide funds, or you file it. There are also under this, we have authorized facilitators who are registered there, who can provide you with assistance to file. So the fee will be borne by the government, the central government, and these facilitators also suggest and give you opinion as to how you can go about filing your trademarks or be it your patents. Then one more thing is the corroboration of the authenticity. What I meant to say is how you protect it. So you have to be vigilant, but how do you know? How can you be vigilant? Here, there is a journal coming up every fortnight, be it in trademark as well as patent offices. These are being published, which is available in their portal. And when you look into the journal, you understand what are the publications that has come up. And if it is close to what it is, then you will not be going towards that also. So it gives you a informed information which is available for the general public free of cost. It is not that you have to pay to obtain those journals. So be it a trademark, we have then come up in different classes, be it patents, whatever is the grant that has been given, it will be published over there. And that is how you will be able to check whether the mark is deceptively similar, or which is that mark is in the market going around, and you can take proper action. So what is the action is, you go for infringement suits, which is again taken up in the respective high courts of Chennai for the southern region. Now, you can say, what is the value? Well, how do I quantify it? So there comes the reason why we need to franchise it or license it, or you have to assign it. These are the modes in which you can transfer the right that you have acquired on an intellectual property. Say, for instance, how does McDonald's work? How does KFC work? So these are all franchising. We have our chaiwalas, we have other startups who have come up. So all these people, when they give a franchisee authority, they have to enter into the person who has brought that to use their particular brand and market it. And licensing is again for patent, because normally how do you transfer your patent right? You grant a license partly or wholly, or exclusive right or a non-exclusive right. And assignment is, it's like a sale. You entirely assign something. Say, for example, in the pharma industries, especially this happens in the pharma industries also, where a particular brand, a generic brand is coming into the market. They wanted to give it for others also to produce. Here, the generic brand, when I take it, I will not be using the brand per se. I'll be taking it and using in a brand which I want. So there you have to take an assignment or a license from them. Only when you obtain the license to use that particular patented medicinal product, you can use it and you can produce it. So these are various ways in which you can transfer all your IP rights. What is the importance of registration? That's what I said. It will give you securing the investment of time and money in your endeavor. Because after all that you have done, you find out one fine morning that somebody else has done it. It's like all your efforts, time, money goes futile, goes to waste. So what is the point? So you have to, that one, be vigilant. Second, timely protected. Also, you should know to convert your IP into investments and create a value. And you have to also show, it is also showing your ownership. So for example, I want to I have patented a brand. I have patented a particular product for pharmaceutical brand. Here somebody wants to take that generic formula, so I have to give them the license. Yes, to obtain the license at the first instance. So unless I have the ownership, I have a proof ownership, I cannot give it to him, otherwise it's going to be copied. So we hear that proof has been established because you go for registration. As I told you, this types of intellectual property, trademarks, patent, trade secret is again very essential again, copyright, geographical indications, industrial designs, plant varieties protection is another arena which is totally untouched. But I feel that there's a lot of scope, especially in Tamil Nadu, because we see the farmers bringing in a lot of hybrid varieties or new variant or extinct variants varieties, which is not at all into circulations. But who has to protect that? How do we protect it? We have, say, in potatoes, as far as I grew up knowing that potato is a tuber which is growing under the soil. But a couple of weeks back, I saw somebody telling me that it is a climber. So I was really amazed. So these kind of extinct varieties, which is exclusively only from a particular region, don't you think even that can be protected and marketed and commercialized? Yeah, we talk about neem milagai. Neem milagai is that which is available only in the cold regions. I would say chiller regions, not cold regions, like OT or Kodaikanal or the belts, which has a temperate zones of between 20 to 28. There they grow. This is a new type, new variety, which is not available in the market, but it has medicinal value. It has the relevance. So who all can protect it? Who all can bring about it to commercialization? How do we bring it to commercialization? As such, we don't have it as a commercial crop. So here, this protection, the plant variety gives you the protection. When you say as a hybrider, or you give it as a farmer, or a person who produces the seeds, in all these categories, you can go register yourself under the Plant Varieties and Protection Act. Semiconductors designs of integrated circuit is altogether which deals with IT and technology. And trademark, so let me move into types of each of the each of the IP. So first is trademark. So what do you mean by trademark? It is nothing but a design or logo or a word which connotes to your product. So how does it create an access? You create, we have around 45 classifications. So the NICE, it's called as NICE classification, under which we will see under what category this particular product is falling into, because we have to categorize the product. So we have to say it as goods as well as services. So first 34 will be denoting the classes, which is talking about the goods, and the rest will be talking about the services. So which means that it is not only for goods that you can bring in a trademark, even for any kind of services, because I bring a retail service. Though I manufacture a product, I'm using the same logo in a class where I'm selling it. So how do I protect that? So I will choose my class according to the need and requirement, the area which I deal with, and that I will combine and file it as a trademark in the registry. Now, how does the protection happen for the trademarks? Protection is, as I told you, first is you go for the registration, and when you choose your classes, you choose either a word mark which should not be deceptive, confusing, or it should not be too generic. See, for example, all of us are having coming up with some innovative brands. I find this brand called Chaiwala. Chaiwala is using it, and everybody starts here. So, with the same trademark as Chai King, Chaiwala. So, the anything which is annexed with chai, that becomes too generic, and you cannot get protection, because chai per se is a very common word used in Hindi for tea. So, when you're using something which should be very unique, if you see Apple, it should not describe the product. And so when I'm going to sell Apple, I should not go and sell Apple. So when I'm going to sell tea, I should not say tea or chai, but it should be something like that. So that is the reason, if you see what has got registered in your head, is if you say Apple, per se, it is for a computers, for a laptop. So it gets registered. So the moment I say Apple, no more gone are those days when I used to say A for Apple. When somebody, even a child, I ask, they say Apple is a phone. So that is the brand impression that they have created. So something very unique, something very not used in the common genre. So you have to select it. Be very careful in selecting your trademark, least because, say for example, if you're going to talk about Swiggy, Swiggy is a coined word because it doesn't denote anything. It doesn't have a dictionary meaning, but it's a coined word. The moment you see a yellow, orange T-shirt, you know that it is something with that symbol, the logo of Swiggy. It gets you're able to recollect. So that is the relevance of trademark and trademark branding. Little would have they thought about, like, maybe one day I'm going to make it big. So you should go for that dream. Yes, my trademark is going to be available everywhere. So when you're branding, so that is promotional branding. So when you want to do a promotional branding, it should stand apart. It should not be confusing, because these will be the grounds on which your trademark will be rejected, and you will not get an exclusivity. So you have to be very careful when you choose your trademark. So that gives you a protection under the Trademarks Act of 1999. And you may ask me, ma'am, is this trademark and trade name the same? No, they cannot be the same, because a company is formed under Companies Formation Act. The company by itself is not a brand. Say, for example, what is the parent company that is of Google? It's Alphabet. So the company name is Alphabet, but the brand Google is a search engine which is known worldwide. We call it as a well-known mark because everybody uses Google. So even to the extent that it has got so generic that, I mean, because of its presence, that because it has become so generic, and genericide has happened for the term Google, because everybody, like how we use Xerox. Xerox is not a trademark. It's a company's name. For photocopying, we are using it as Xerox. That is not the usage. That is not how it happens. So there was a litigation, and we say henceforth in our public services also, we are forbidden from using Xerox because it is their exclusive right, their exclusive property, Xerox. So we cannot use it anymore as Xerox. We call it as a photocopying machine. When we say, Xerox எடுத்துட்டு வாங்க, அப்படி சொல்ல முடியாது. We have to say it as photocopy எடுத்துட்டு வாங்க, because the service is photocopy. But Xerox is the company which has got the trademark. So sometimes it becomes so generic in usage also that it becomes, we call it as genericide in our language, because it has lost the value. So that exclusivity. Of course, yes, this is where we say that we have to be very vigilant when they take the action. So somebody is using it, they can take action against them. Please don't use this, because there's always a chance of misusing the product or the brand. That is what we call it as passing off, because I use the name Xerox, and it is impliedly understood for me that okay, that means it is photocopying. So that means I am just passing off that brand under some other name. Recently I just came to see that when I was traveling in a public transport, I saw a meter fixed in an auto, wherein that particular company is using the Apple logo per se. Here, sitting somewhere in US, they have a protection granted by the trademark office, not only in US, they have their mark registered here in India. So they can take action even on a small timers. It only sees how vigilant you are to protect your mark. So that is the reason we always say when you get your trademark registered, after the whole process, which roughly takes around 8 to 9 months these days, you have to use the mark R on top of your brand. That means we say that we are registered. We are very vigilant. We will take actions against you if you abuse our mark or infringe our mark. We can say it, abuse in the sense like you use the label that is passing off, or you infringe my mark. Then I have every right under the act to file a suit against you and take actions wherein we can recover damages in the sense to the extent of the loss because of they using it. You are losing your business, you are losing the value of your business. Somebody is taking the fruits of your toil. So how do you protect it? By taking actions against it, by filing for damages and ask the court for appropriate actions. And there is also scope for collective and certification marks, which is not like you call it as the ISA mark or the BIS mark, or we call it the HAL mark. All these are collective marks. This also can be registered because we are using it for certification purposes and for using it. Say, for example, a jewelry is selling a product. They are having the HAL mark. Then we have the silk mark. We have for the handlooms also the handloom marks. So all this will give you the collective feeling that that has passed through that test. So somebody says that I have been using this, I have got the BSI mark, we are using the BSI mark. How did they obtain it? When they are using it, they should get the permission from, or they should have registered themselves as a trademark. An interesting note is this trademark confined only for companies, or there are individuals also who can who are celebrities and try to protect them? For example, Sachin Tendulkar, Shah Rukh Khan, all of these people have trademarked their name per se, Salman Khan. So because trademark is not only a logo, or it can also be a word. So I have branded myself. So when Shah Rukh Khan has registered his name, nobody can misuse the name of Shah Rukh Khan anywhere. So that is to the extent of protection that is being granted under the trademarks. Next is a very important and very relevant for most of the startups and entrepreneurs. What is patent? Patent per se is an innovation of technology, and that can be both in a product as well as in process. So when you're trying to protect your patent, either by a product or as a process, what is that you have to do at the first instance? There is a process called a prior art search. We search that. Search if there is availably some mark or to that effect, some invention to the close to that, and where do we differ? Because these days everybody is registering their patent, but somebody should have registered and they've not brought it to commercialization. So what will happen to that? In such a case, that publication that has been carried out after the grant, you check to see the availability of already existing patent. Instead, you need not waste your time sitting and working on it again. You can go and ask for a license. You can ask for a franchises. That is where you bring in the commercial aspect of a patent. So this is a very important right, and this is the fundamental. That is the reason I said they have given 80% rebate also in the official fee for patent filing, as well as the government, central government has given the SIP program, wherein you can register your patent through a facilitator who will aid you in finding out this. As I told you, in the prior art search, they will look into it. They will see the forms, because patent filing is not simple, as I can tell you. It's not simple because it includes a process. It can be a provisional one, or it can be a complete one. So if it's a provincial, why do we file provincial? Because the moment I come up with a new ideation, I wanted to bring it to I see to the feasibility and I see the executability. So before somebody else can claim the priority, I want to claim it. So whatever is the little inventions that I have, I put them as claims And later, within a period of 18 months, I should give them the complete specifications, telling them that to the patent office that I have completed my project and this is how it is. So we give it in the form of a claims. We claim it. So also we have to refer to the previous inventions that we are referring to, and that on that base you will be claiming that I'm bringing these other changes in the process. So the executability is there. So what is the duration of this patent is? It's going to be for 20 years. So with 20 years, you will be given the exclusivity. Within that, you can commercialize. You can bring out, as I told you, a franchisee, or you can give them a licensing or an assignment, and you can create a value for that. So these are all the rights of a patent owner. Uh, and as I told you, very relevant to today's topic is why patents should be protected. And copyright is again another intellectual property right. It is also a right for, you can ask me for what kind. It is for literary work. Artisans are there who are always creators, people who are writers, authors, people who produce music, people who bring out movies. All this or all human creation. Somebody is creating it. Somebody's labor is put into it, money has been put into it. So somebody very easily takes it and reproduce it. What is my right? How will I protect my right? So copyright is precisely for art, literary work, as well as other human creations through artisans. Here we can say copyright is very relevant because the ownership is a big stake here, because there are too many people involved. For example, composing a song, the producer is there who invests money. He hires the music director. He composes the music. He hires people to lend their voices for that creation. So this again is a process. But in this process, who is the absolute owner of it? How do we confine the right? So that is where we, if you can recall the Ilayaraja's case, wherein the music composer is the original producer. So he is given the copyright and he has got the right to stop anybody from reproducing his composition, because music per se is the fundamental on which something is being added on. So that composition, when somebody is reproducing, they necessarily have to take the permission of the composer. So that right is being set right here in copyright. So the other, likewise, if it's going to be a book, I have created a book, I have written a book, don't you think I have to give some right to the publisher who's going to publish? Because I'm giving him some right to produce my thing. So he says, in turn, he's publishing the work. There, what is my right? He says, I'll pay you so much royalty for this number of years. So I get my royalty. Likewise, a creation, okay, say a Tanjore art, or we are talking of any other art pieces. It is my human creation, a painting. It is my human creation. I would like to put it where, how, to whom. So that right on my creation gives you the right under the Copyright Act. And is it, what is collective management of copyright is? That's what I said. There's a process involved. When we make a movie, the director is there, the assistant directors are there, the actors are there, the producer is there who's investing. So it is, how do you collectively manage all this, and who is gets vested with what right? And again, there are different forums which has been created under the literary, that is a committee will be formed, wherein they are taking the license from the particular companies, and whoever wants to reproduce that, they have to take necessarily from them the permission or the right. So in turn, there is an commercial aspect created for the right that has been given. And as I told, the classic example of infringement, as I told you about the Ilayaraja's case, which we understand. Next is a very important and very relevant topic for today, because we have a geographical indication, which is nothing but it comes or originates from a particular locality or territory. So say, for example, if you're going to say Kanjipuram saris, Pattasari is coming from Kanjipuram. Okay, there are other silk sarees available within the Tamil Nadu. Like for example, you have a Tirubhuvanam Pattu saree, you have Arani Pattu saree, you have Dharmavaram Pattu saree. Then you have, if you're going to just stretch it even further, how do you differentiate? There is this differentiation, this uniqueness, this difference between each product is being well established when you file a GI. Say, for example, RNE, they say the VARP. The VARP means the number of the silk thread count. That is different when compared to Kanjivaram. The border annexing of the Anjan and the Mundani children. So whatever that Mundani, when you're annexing, the way in which it has been annexed, because all these involve human labor. These are all hand looms that is physically done by an artisan. So they say that to produce a Kanjivaram sari, it takes 25 to 30 days. The pure Kanjivaram sari, which we are talking about. Don't you think the labor of that artisan should be protected? Who will protect it? How will it be protected? Here is what this particular IP is different from the other IPs I was talking about. Here, the government plays a very active role and says that I'm not going to confine it with only one particular person, because trademark, if you say it is pertaining to a person, a particular company, but geographical indication is not like that. It is called a communal mark. And this particular sui generis is, or we call as a legislation exclusively for India, because in other countries at an international level, we call it as appellation of origin or the place of origin. That is how they were trying to protect the wines or the cheese or other products that has been coming up, for example, any hearty works or anything like that. But here in India, we have, it's being a vast country with a region well spread with resources, be it textiles or be it artisans' work or be it foodstuffs, all these. So the goods are enormous. So we have 34 classes of goods available. These goods have to be protected. How do we protect it? They said somebody interested, vested interest. So it can be a facilitator. That is the reason we say the NABARD of Madurai would have filed it for Madurai Malligai. How is it? What is the stakeholder? Who is the stakeholder here? So somebody facilitating to uplift the artisans or the producers or the persons who are manufacturing and originating from that particular region, we are trying to protect as GI. And I'm proud to say that I have filed for Kanyakumari cloves. When we had it, the process was very humongous, if I can say, because it involved a lot of research. We had to see the gazetteer, because whenever we talk about geographical indication, we talk about the tradition attached to it, the origin, how did it originate? How is it unique? What is it from that geographical indication that gives a uniqueness to that particular product? So a very interesting case I would like to refer, which was litigated in the Madras High Court for the Tirupati Laddu. Tirupati Laddu is a prasad that has been dispersed in Tirupati. So that laddu, feature of the laddu, it is registered foodstuffs. The feature of that laddu is that you can see that Urmadri, the sugar will be looking coated and it will be hard and dry. Whereas you always see laddu very moist, is it not? And the taste also, because we are using the same ingredients of basin flour, we are using all the dry nuts, everything. Why is that we are not able to produce it anywhere else, and or why don't we get the taste? It is for the reason that it was found out that the water content, the climatic conditions, even if you say right up in Tirupati, when you get that laddu, the same laddu is not available in Tiruchanur, which is Tirumala, down in the plains. So the climatic conditions in which it has been made, the manner in which it is made, all this gives a preservative life for it, even without, you need not hold it anyway. They say that Tirupati laddu can even be stored for a month. So that is the uniqueness. So there are so many factors which influences a product. So we can say about this Manapare Muruk, then Kadla Mitai, which we have. Then foodstuffs of all this, we have the pedas, which has come up from northern Karnataka. Then we have some of the fruits also. Say, for example, this Panir Draksha, which is only available in Kodaikanal, which I understand it comes from that belt. So we are asked to submit a map in which this particular product has been produced. That is the reason we find that a lot of geographical indication process to come through for an application is very, very humongous. A lot of work has to go through it. And once we get it, it is a pride for us. And I think this is the right moment for me to also tell that Tamil Nadu is spearheading in filing number of GIs. And I think we are leading among all the states for filing the GI. So that is relevant. So we are trying to preserve the lives of the artisans, whoever it be creative in textiles, foodstuffs, or all these people are small timers. So they need proper protection. And the government is crusading as a facilitator, giving them a communal mark, because in Kanjipuram, it is not one society that is presiding, producing Kanjipuram saris. There are so many societies registered and following the process of the Kanjipuram sari. And another unique feature about this GI is that, okay, I'm also a trader. I'm a manufacturer. I'm not a manufacturer, but I trade Kanjipuram sari exclusively. So how do I get that right? So here, GI Act gives you a special provision, says that any authorized user, like for example, I'm putting up a shop somewhere in deep south in Titicorin or Tirunelveli, exclusively a shop for Kanjipuram saris. How do I prove? It's like how will you get a BISI mark? Here, if you have the tag of the geographical indication, that means it has gone through the test, because there is an internal committee which checks into the product veracity, and they will certify that this is coming up from there. So when it holds a geographical indication, it means that it has gone through the rigors of the test of purity as well as the originality, and that can be safely taken. So this indirectly helps us boost to send products outside, be in exporting it or any thing. As well as there are a lot of governmental schemes to promote this geographical indications also. You put in international exhibitions, there are grants being given by forums like MCCI or any forum which promotes these kind of artisans, and so it will be a good basis also for all these kind of associations or what we call as industry or federation bodies to come up with certain promotional activities for all these GIs which we have, so we can bring it to commercialization. So we are also crusading as a facilitator for GI. Also, we are crusading and encouraging people for all using these GI products to come register themselves as authorized users, so that they are within the list and their protection will be extended. As a registered proprietor, the same right will be extended even to an authorized user. So he can also step into the shoes of a registered user and take actions on any infringer, because I am producing it, I'm putting in my labor, I'm an authorized user. I can also take an action, legal action of infringement if somebody misuses the GI that has been created. And industrial design is another form of a patent variation, we can say. What can't be, suppose you are developing a product, what can't be patented? It is already there. Then in such a case, say for example, we have this Coimbatore wet grinder. The wet grinder has, initially it was the drum that was rotating with the stone intact. Now we have the stone rotating, whereas, so the design has changed. So how do you protect it? It's already available in the market. It is it has come into commercialization. So this design change, which has a 2D or 3D effect, can be protected by an industrial design before bringing it into a commercial aspect. Again, here also, this is nothing but a 2D effect or a 3D effect of any product developed with a design change. Like for example, you have some jewelry, you have a jewelry set, you have a tea set. All this, you are imbibing some changes, because tea set per se is available there, but you're introducing something for a design over there. Or your say for example a jewelry set, you have you can say that harem is there, a chain is there, a necklace is there. It's a very generic one, but if you bring about some changes in the design, that can be protected. So whenever we bring in changes with an already existing product, but you are able to bring in a 2D or 3D effect, these kind of industrial designs can be protected under the IT Act. But of course, we do have certain exceptions wherein we can't protect some of the industrial designs also. So,
Hello, ma'am.
in,
Am I audible? This is Mageshwar from StartupTN.
Yeah, we can hear you, Mr. Mageshwar. Yes.
Ma'am, just a gentle reminder, we are past time.
yeah, I'll take hardly another 1 or 2 minutes, Maheshwar, and I can wind up.
Sure. Sorry, thanks.
Thank you.
Yes. So all these kind of industrial, so just to tell a few of the things that cannot be protected under the ID Act is, like you can say about books, jackets, calendars, certificates. All these cannot be protected because these are all the generic ones that is available. Likewise, you cannot protect a label, a token, some cards, cartoons. So these kind of though they can have a picturization, they bring in some changes. These are not coming within the purview of, that is what we say as exclusivity, which we exclude and doesn't come within the purview of industrial designs. So the last is, what should be the strategy? Rightly before my introduction, ma'am had very clearly put in that you need to devise an appropriate strategy before you come with launch of your product. So that is, one is your protection. Second is you don't disclose it. And third is the tools that is available for your various forums. So you have to see how this IP will fit into maybe. So, and also the legal IP framework surrounding all this. So when keeping all this into consideration, you have to devise an important strategy when you are going to bring out the protection for IP and your product. So all the very best for all the startups. And I think with this, I wind up my session. And in case you have any queries, you can raise it.
Hello. The questions can be put on the chat. We have, as we are short of time, we can take 2 questions. Ma'am, there are 2 questions already in the chat. If you can read it and address, it will be great.
Yeah, I'm going through the charts message put in there. Somebody has asked me, are you referring to Indian patent in your presentation or US patent? We are talking about your Indian patent registration and the programs that has been offered under the DPIIT for startups. And somebody has asked me about non-usage of non-generic brands name. Why do we still see trademarks such as MBA, Chaiwala, Child Point? Yeah, this is what I said. See, what happens is when a logo is there, we bring a logo very distinct. We give a different color. Somebody, maybe probably Chaiwala, whoever is the first registered person of the chai, generic term chai, he wouldn't have taken it in a word. So the word protection is under trademark is available under 2 counts. One is a word protection as well as we call it as a logo or a label. But when it is something very generic in term, the registry themselves tell you, we can't give you the exclusivity. So whoever is registered as chai, they will say that chai is excluded from your exclusivity. That will be a stipulation when they pass them and they ask them to use it only as a logo. So a lot of people will bring in and use the word chai. That is why we said it's becoming very generic.
So ma'am, hi, Dave here from Emerging Legal Team. So this is because of the way they have written the font and the color, the combination which they have used. For that basis, they have been granted the exclusivity, correct?
Yes. If it's a word, it gives you absolute exclusivity. That is the reason we always recommend when you coin a term, please take it in the word form. And likewise, we also advise when if a label has been taken, though color has been protected under the Trademarks Act, we always say that there is a provision under Section 10 which says that you have to go on black and white for getting an absolute protection. So when you register it in black and white, you get an absolute protection no matter what the kind of color is. But generally what happens is labels these days, we say people are going with a color because registration of trademark gives a protection even for a color. Say for instance, if it's going to be McDonald's, yellow and red, everybody is quite conversant with the color. The moment the M logo is there with an yellow and red, your recollection goes there. That's why I referred to Swiggy an orange t-shirt and Zomato or a t-shirt. So this the colors that they like to emphasize. But the better option is to go in a black and white. No matter somebody else use a different color and the logo over there, then they can claim, they can take actions against them.
Can I talk?
Hello. Thank you. Thank you. We can
Just
take one more question.
Can I talk? Babu Ranganathan here from CAN BRS Therapeutics. Am I audible?
Yes, please go ahead.
Yes.
Yeah.
Sorry to ask. I mean, normally, how much will be the cost to have a US patent? We are in biotechnology.
I'm not confined to discuss the fee. Official fee is different, and it depends whether you're going for a mandate. You're going to go for your PCT filing, or it's going to be a state filing. All that is important. So it requires further discussion.
Okay, thank you.
So we can take one more question.
Yes.
Shivakumar, please go ahead.
Hello. Hello.
Yes, please go ahead. Yeah.
மேடம், இப்போ ஒரு பேட்டன்ட் பண்றதுக்கு வந்து ஒரு இன்வென்ஷனையோ ஒரு ப்ராசஸையோ பேட்டன்ட் பண்றோம். ஒரு யூனிக் கான்செப்டை வந்து பேட்டன்ட் பண்ண முடியுங்களா?
அதான் நாங்க சொல்றோம், ideation per se is not an IP. You have to convert that ideation to either under what IP can it be fit into. இப்போ நீங்க கான்செப்ட்னு சொல்லும்போது என்ன மாதிரி கான்செப்ட், அது வந்து அதை எப்படி கன்வெர்ட் பண்றீங்க, அதுதான் வந்து is protected. Ideation is not an IP.
இல்ல ஐடியேஷன் இல்ல, அந்த கான்செப்ட ப்ராப்பரா இம்ப்ளிமெண்ட் பண்ணி அதை வந்து பேட்டன்ட் பண்ண முடியுங்களா அப்படின்னு கேக்குறேன்.
It depends on how you're working on the concept, right? What is the concept?
Okay.
Okay. Thanks, Shivakumar.
Thank you.
So, due to paucity of time, I have sent my email ID to everyone here in the chat box. You can send the queries to the email ID so that we can address it within a few days. So can we close the session, ma'am?
Yes, I think that can be done, Mr. Maheshwar.
Yes. So, on behalf of StartupTN, I'd like to thank the Madras Chamber of Commerce and Industries, the Secretary, ma'am, for giving this opportunity of collaboration. And we look forward to do a lot of events. And it was very positive, and we had made it in less than a week's time, as I'm told. And I hope the session was very fruitful to whoever attended this. And we also can get feedbacks to the email mentioned in the chat box. Thanks to Savithri ma'am for her time, and it was very sweet that you had extended the time and I mean the queries also. So we look forward to associating with you in the future also. So thanks once again for the fellow participants for being patient and being a very positive crowd. So we'll address the questions via email, and thanks for attending this session. Thank you.
Thank you, Varun.
Thank you.
Thank you very much.
Thank you, Ms. Maheshwar and Mr. Thank you very much. Yeah.
Thank you, ma'am. Thank you. Yeah.